Mr. Graham.
Thank you, my Lord. Before we broke, we were about to look at paragraph 18 of the re-amended Schedule 5T, where SCAT pleads the falsity of various representations. In paragraphs A to D, it's dealing with the Annex E representations. Could I, in the interest of time, just ask you to speed read yourselves A through to D?
Yes.
Paying particular attention to D on the next page. So, my lords, you can see that in subparagraph A, SCAT adopted the admission in ED&F Mann's defence that the Annex E pension plan clients had not received the dividends identified in the tax voucher and had not suffered the withholding of tax set out in the tax voucher. But there was no allegation, either in this paragraph or anywhere else in Schedule 5T, corresponding to any of the four significant factual elements that the judge identified in paragraph 69 of his judgment, which I showed to your lordship shortly before lunch. So in SCAT's original claim, in respect of the Annex E applications, there was no allegation that the pension plans did not own the shares. That's the point the judge makes at paragraph 69 sub 1 of his judgment. There was no allegation that the sellers from whom the pension plan clients bought shares did not own the shares or were naked short sellers. That's 69 sub 2. There was no allegation that the underlying trading was circular and involved the pension plan clients and the sellers buying and selling to each other shares that neither of them owned. That's 69 sub 3. And there was no allegation of fraud, i.e. no allegation that particular individuals within ED&F Mann knew that the pleaded representations were false or were reckless as to whether they were true or false. 69.4. A very much larger number of the tax vouchers, 340 out of the 420, were categorised, as your lordships now know, as non-Annex E tax vouchers, and the allegation of falsity in respect of those tax vouchers is at paragraph 18E, which your lordships may already be on if you've gone over the page and read 18D. In paragraph 18E, SCAT alleged that, in any event, and with respect to the ED&F Mann applications not contained in Annex E, the relevant pension plan did not hold and was not the beneficial owner of the specified shares and had not received any dividend as beneficial owner net of withholding tax. Paragraph 18E(1) then said, to the extent that the specified shares were purchased and the relevant pension plan held any interest in the specified shares or received any payment by way of dividend, it did so for the benefit of ED&F Mann. And then in paragraph 18E(2), it was alleged that ED&F Mann, rather than the pension plan, was the beneficial owner of any specified shares or any dividend received by it. So in respect of the non-Annex E tax vouchers, SCAT's pleaded case was that if the pension plan clients had owned shares and received dividends, as to which SCAT did not plead a positive case, then the beneficial owner of such shares and dividends was ED&F Mann and not the pension plan clients themselves. And the fact that that was the nature of SCAT's case, and that was how it was understood, is put beyond doubt by the further particulars that SCAT served in relation to the validity of the withholding tax refund applications made by ED&F Mann's pension plan clients. Your lordships will remember Mr. Justice Andrew Baker ordered a preliminary issue trial on the revenue rule and then on what he called the validity trial, and parties had to prepare their validity particulars and indeed defences to validity particulars. I was going to take you to that, I'm not going to now. The reference to it though is Supplementary Bundle Volume 1, tab 13, page 225, and the relevant paragraphs in that are 31, 31.1, 44, 47, and 47.1. My learned friends seek to muddy the waters somewhat as to what Scatt's pleaded case was, but the reality is that the ED&F man understood perfectly well at the time what the case pleaded against it was, and one can see that from ED&F man's defence to the validity particulars that I've just been, and those paragraphs I've just been referring to. That defence is in the same bundle, supplemental bundle 1, tab 14, page 235. And again, I'm not going to take you to it, but for my Lord's notes, the two paragraphs which I was going to read through with your Lordships are paragraphs 2.3.1 and 2.3.3, both on page 236. And if I could ask you to follow those references in due course, I'd be most grateful. Yep. As far as the current claim is concerned, Scatt's case is that ED&F man's pension plan clients did not own Danish shares, did not receive any dividends, and did not suffer any withholding of tax in Denmark. Scatt's current claim alleges that ED&F man's pension plan clients purported to buy Danish shares from sellers who did not own any Danish shares, then that the sellers purported to cover their short sales by buying back from the pension plan clients the very shares that they had purported to sell to the pension plans in the first place. And
this applies both to the annexee and the non-annexee.
Yes.
Yes. All the claims.
Yes. Yes. And this circular trading did not result in either the pension plans or the sellers ever acquiring ownership of any Danish shares.
Or dividends, presumably.
Or dividends, yes, yes. So if you needed to be a shareholder to get the dividends, so there's no beneficial owner case in the new claim. I couldn't help noticing that when my learned friend explained the trading structures to your Lordships yesterday, he made repeated reference to the pension plan clients buying or otherwise acquiring shares. Again, I was going to go various points in the transcript, but you can, I'm sure, find those. That was part of the earlier claim, but it is no part of the new claim. The new claim says whatever transactions may have been entered into, there were no shares acquired, there were no shares bought, because the way it worked was if the seller sold the shares to the pension plan on day one, pension plan sells them back to the seller on day two. You've got a series of contractual rights, but no shares.
Well, it may be strictly inaccurate to say you bought, but you contracted to buy.
You contracted to buy,
but you
contract to sell.
Yes.
And so that's why that summary of the trading structures it was not accurate so far as the new claim is concerned. Important to recognise that the trading structures are complex, and the scope, we would say, for something in the trading structures to be different and to make a difference is significant. So I don't propose to take my lords through the pleading of the current claim. The judge, we say, accurately summarised the key features of the pleaded claim that were new significant elements at paragraph 69, which I showed you, Lordships, before lunch. And my learned friends do not say there's any inaccuracy in that summary. But for my Lord's notes, the Scatt's particulars of claim in the current claim is in the core bundle behind tab 11, and the key paragraphs to have a look at are paragraphs 22 to 24, 26, 27, 35, 38, 40, and 42. My Lords, I hope I have responded to many of my learned friends' points in the course of my submissions thus far. But if I may, I'd like to make two further points. The first of them is that we submit that the key question is whether the issue on Dicey Rule 3 that might be thought to arise on the facts pleaded as part of the new claim has already been decided against Scatt by Mr. Justice Andrew Baker. And we say quite plainly it has not. Our primary submission is that that is the end of the road so far as issue estoppel is concerned. Now, I was going to go on to make a secondary submission, which is that the differences are relevant to the application of the revenue rule in any event. If it's necessary to consider whether the factual differences between the earlier claim and the new claim are relevant to Dicey Rule 3, there is no reason we submit, and I've touched on this before lunch, why your lordship should not do that by reference to the principles. There's no reason why your lordships should be doing that by reference to the principles set out in Mr. Justice Andrew Baker's judgment, which we now know to be wrong. The relevance or irrelevance of any issue in the new pleaded facts must be judged by reference to the correct legal analysis as set out in the Supreme Court's judgment in our submission.
I don't understand why you say that. If the only judgment which is said to give rise to an issue estoppel is Mr. Justice Andrew Baker's judgment, isn't the question what was regarded as material so far as that decision was concerned?
Yes, if one answers that in the sense that I've sought to explain to my lords before lunch.
So why then is it relevant to look at what the Court of Appeal or the Supreme Court
because if the Supreme
are the relevant considerations?
Well, if, for example, the Supreme Court makes it plain that a pleading of fraud is relevant
Yes.
to whether Dicey Rule 3 applies,
Yes.
that is something which we say was not decided as between SCAT and EDFM in the first instance hearing. What was decided as between them was simply that a claim in negligent misrep fell foul of the
I understand that submission, but the point we're on is it relevant whether it was a claim in negligence or fraud? The fact that the House of Lords might have thought it was can't affect the question of issue estoppel, can it? If, in formulating and deciding the issue, Mr. Justice Andrew Baker thought that it wasn't. That's the point I'm on. I don't quite understand where the Supreme Court comes into it.
Well, my lord, where we say it comes into it, the question is whether the new claims pleaded first in 2022 and looking at them now in 2024 gives rise to the same issues as have already been decided as between SCAT and EDFM. And for that, one needs to know what the current law is as to whether a different factual allegation will make a difference or not. So in 2024, if one asks oneself, does the pleading of fraud make a difference to the application of Dicey Rule 3, then one's entitled to look at the Supreme Court's judgment in our submission in order to answer that question. It is only if if the court were to take the view that whether fraud made a difference was something that was part of the issue estoppel, that one would run into difficulties. But in our respectful submission, it can't do, because what was decided as between SCAT and EDFM was simply whether a claim in negligent misrep fell foul of the rule.
Did the Supreme Court say it made a difference? I thought the Supreme Court and this court said that both the negligence claims and the deceit claims were equally outside.
Well, they did. But what the Supreme Court said in paragraph 40 of its judgment is that it was common ground that if Dicey Rule 3 already applied, then the fact that you added a fraud allegation, so if you already had an allegation that someone was evading tax, a claim that someone was evading tax, it wouldn't take it out of the ambit of the rule, if there was already an unpaid demand for tax, to allege fraud. But beyond that, we say they didn't go. I think it should take my lords to the Supreme Court judgment to make that good. It's Judgment Bundle, tab 6. And I want to pick it up, please. If we look, please, at paragraph 2 of the Supreme Court's judgment. That's at page 226. You can see there that the Supreme Court set out what we've been calling Dicey Rule 3, which they call, no doubt rightly, Dicey Rule 20 sub Rule 1. And as your lordships know, the rule states that the English courts have no jurisdiction to entertain an action for the enforcement, either directly or indirectly, of a penal, revenue, or other public law of a foreign state. And just below the ruling, Lord Lloyd Jones says the essential questions arising on this appeal are the scope of Rule 20 sub 1 and whether it has any applications to the facts of the present case. In its application to the tax laws of a foreign state, the principle is often referred to as the revenue rule. For convenience, its application to the public laws of a foreign state will be referred to in this judgment as the sovereign authority rule. And so Lord Lloyd Jones was saying that Dicey Rule 3, Dicey Rule 20 sub 1, comprised two relevant elements, the revenue rule and the sovereign authority rule. And in its judgment, the Supreme Court considered the revenue rule from paragraph 21 onwards. That's page 228 of the bundle. And you should see, if you flick forward to there, a heading in italics, underground one, the scope of the revenue rule. And if your lordships were next to turn to paragraph 40, which is on page 235 of the bundle, you will see the Supreme Court recording that it was common ground before them, correctly in the view of Lord Lloyd Jones, that, and I'm going to emphasise the next words, where the revenue rule otherwise applies, fraud does not of itself remove a claim from the operation of the revenue rule. It's worth noting in our submission how narrow that common ground was. The common ground was not that an allegation of fraud is irrelevant to the applicability of Dicey Rule 3. Thus, for example, an allegation of fraud might be relevant to the question of whether there were unpaid taxes due from the defendant to the relevant tax authority, or to the related question whether there was a relevant tax authority-taxpayer relationship in the first place. It is true that fraud by a taxpayer in evading tax does not remove a case from the scope of Dicey Rule 3. That's made clear in the second sentence of paragraph 40 we've been looking at, and also the approach of this court taken on the revenue rule appeal at paragraph 134, that is J4/135 to 136. The fact that an allegation of fraud can be relevant in deciding whether there is a taxpayer-tax authority relationship is apparent from the next paragraph of Lord Lloyd Jones's judgment. Might I ask, my lords, please to read to yourselves paragraph 41, which starts at the bottom of 235 and goes over the top to page 236.
We'll do that.
Thank you so much. And so, as my lords will have seen, in the concluding sentence of that paragraph, Lord Lloyd Jones said, this attempt to portray the applicants as taxpayers cannot bind the respondent as the victim of their fraud, and the applicants cannot take advantage of their own wrongdoing in order to bring themselves within the revenue rule. And so, in our respectful submission, Lord Lloyd Jones was in fact taking the fraud allegation in Scatt's claim, not against ED&F, of course, but against the alleged fraud defendants, into account in order to decide whether there was a relevant taxpayer-tax authority relationship, and therefore whether there was an outstanding tax debt. So the Supreme Court, in our respectful submission, thinks that fraud will be relevant in relation to the revenue rule in certain circumstances, the common ground referred to in paragraph 40 being limited in the way I've explained. The Supreme Court next addressed what they call the sovereign authority rule from paragraphs 53 onwards. That's page 238 of the bundle. Sorry, it's paragraph 239 of the bundle. Just above paragraph 53, the Supreme Court set out ground 2 of the appeal, which was concerned with allegations that Scatt had used its sovereign powers to assist in the prosecution of its claim. A key passage of Lord Lloyd Jones's judgment, where he applied the sovereign authority rule to the facts, is at paragraph 58 on page 241 of the bundle. There what is said is, in the present case, the appellants are undoubtedly able to point to prior exercises of sovereign power by Denmark in creating its laws relating to the taxation of dividends and in operating the tax system. This, however, merely provides the context for the present claims. The substance of the claims, as we have seen, does not involve any act of a sovereign character, any exercise or enforcement of a sovereign right, or any vindication of a sovereign power. On the contrary, the respondent is simply bringing restitutionary claims to recover monies of which it has been defrauded, a course open to any private citizen who had been similarly defrauded. Furthermore, as the Court of Appeal pointed out, the attempt to challenge that conclusion by seeking to characterise the payment of the refunds as sovereign acts does not assist the appellants. First, even if, notwithstanding the fact that they were induced by fraud, the making of the payments was correctly characterised as a sovereign act, there is no reason why an attempt to recover the payments should be considered a vindication of sovereign power. Secondly, the respondent is not seeking to vindicate the payments, but to invalidate them on the grounds of fraud. So, far from holding that the fraud allegation was irrelevant, so far as the sovereign authority rule was concerned, Lord Lloyd Jones's reasoning was that SCAT was not exercising sovereign authority because bringing a restitutionary claim to recover monies of which you've been defrauded is a course open to any private citizen.
That's because fraud was the particular mechanism that was being considered at this case. But nothing in that paragraph depends upon it being fraud. If instead of defrauded, it had said negligently misled and vindicate the payments, but to invalidate them on the grounds of negligent misrepresentation rather than fraud.
Well, I think, my Lord, with,
none of the reasoning would be any different, would it?
well, I think it might, my Lord, because if you've got a claim in fraud, it would be my respectful submission that you could seek to invalidate the payment on the basis that fraud unravels all, and that that payment should never have been made. Whereas in a claim for damages for negligent misrepresentation, you're approaching it in a very different way. You're saying, I have been deprived of money. Money has come out of my pocket because you persuaded me to make these payments. You should never have done that. I've got a claim for damages against you. That is different in character and from the case that's where the fraud enables one actually to unpick the payment itself, to invalidate the payment itself. In the Court of Appeal's judgment, again, I think the looking at the paragraph I referred to just now, I think paragraph 134 it may have been, the public policy exception to the operation of the revenue rule is specifically only applicable in terms of fraud. So there's another reason there as to why the pleading of fraud might well make a difference. So, my Lord, we say the characterisation of the new claim, in order to identify what issues it gives rise to, must take place against the background of the current law. Only after that can one go back to Mr. Justice Andrew Baker's judgment to identify whether the same issue arose and was decided, thereby giving rise to issue estoppel. SCAT's new claims against ED&F Man, which involve fraud, need to be characterised, we say, by reference to the relevance that would be attached to them under the current law in relation to the application of Dicey Rule 3, by reference to the judgment of the Supreme Court. So we say, far from holding that the fraud allegation was irrelevant so far as the sovereign authority rule was concerned, Lord Lloyd Jones's reasoning was that SCAT was not exercising sovereign authority because bringing a restitutionary claim which you've been defrauded is of course open to any private citizen. And I mentioned, I think before, the importance that an allegation of fraud means that SCAT is seeking to invalidate the payments that were made rather than seeking damages. My Lord, the Supreme Court's reasoning as to the relevance of fraud to the sovereign authority component of Dicey Rule 3 is also reflected in the judgment of this court on appeal from Mr. Justice Andrew Baker, as I've mentioned. And for my Lord's note, that judgment is in Bundle J, tab 4. I've mentioned one of the points they mention about the public policy exception. That's covered in paragraph 146 of the judgment of the Court of Appeal from the Chancellor, Sir Julian Flo. The other paragraphs I was going to take you to, paragraphs 129, 130, 137, and 143. 146 being the one that deals with the public policy exception of permitting the recovery of money extracted from a foreign state by way of fraud. And that is the public policy exception being referred to by the Chancellor in the Court of Appeal judgment. One needs to look at Scott's submissions, page 780E, which is at J4/94. So, my Lords, we say, my learned friends are wrong to assert that the fraud allegation is irrelevant to Dicey Rule 3. My learned friends also face a further problem in relation to the relevance or irrelevance of the new allegation to Dicey Rule 3. Scott's current claim alleges that ED&F Man's pension plan clients did not own the shares at any material time, did not receive any dividends, and did not suffer any withholding of tax in Denmark. It follows that they never had any tax liability in Denmark, and there never was any taxpayer-tax authority relationship between Scott and ED&F Man's pension plan clients. As I sought to explain earlier, Scott did not make that blanket allegation in the earlier claim. Rather, in respect of the vast majority of the ED&F Man applications, Scott did not allege a positive case that ED&F Man's pension plans did not receive dividends or suffer withholding of tax in Denmark. In the Revenue Rule judgment, Mr. Justice Andrew Baker referred to the fact that it followed from Scott's pleaded case against ED&F Man that a very large proportion of ED&F Man's pension plan clients did have a tax liability in Denmark. And I should just show my Lords that passage. It's paragraph 13 of the Revenue Rule judgment. If you've still got Bundle J before you, you want to head to tab 2, and within that go to page J23. Might I invite my Lords, again I was going to read it, but in the interest of speed, can I ask you to read paragraph 13 to yourselves, noting in particular the passage which refers to the ED&F Man applications, referring to the applicant as being the party with a tax liability in respect of which the withholding tax was deducted.
Yep. Yes.
So, my Lords, my learned friends do not and cannot say that the question of whether there was a tax authority relationship between the relevant applicants and my client Scat is plainly a relevant distinction, and one can see that from paragraph 42 of the judgment of the Supreme Court. I've already referred you to paragraph I think the reference in paragraph 41 to the defendants in that case, the alleged fraud defendants, being unable to to present themselves as being taxpayers. If we go to paragraph 42, which is on page, forgive me, page 236, picking it up at letter B, nor are the appellants assisted by seeking to mischaracterise the claim as the vindication of the respondent's asserted right to recover overpaid refunds. The appellants were not in a tax relationship with the respondent. the present claim for damages and restitution lacks the character of a charge by a foreign state pursuant to its tax laws. Pausing there, the implication we submit from what Lord Lloyd Jones is saying here is that if the applicant had had a tax liability to SCAT and had thus been a taxpayer by virtue of the withholding of tax and in a tax relationship with SCAT, the claim might fall to be differently characterised. Unlike the claim that SCAT had pleaded in its earlier claims, SCAT's pleaded case in the current claim is that ED&F Man's pension plan clients owned no shares and received no dividends, and therefore had no tax liability in Denmark, and therefore that there was no taxpayer-tax authority relationship between the pension plan clients and SCAT. And as the Supreme Court explained in the passage in paragraph 42 I just showed to my lords, that is a relevant distinction in our submission for the purposes of Dicey Rule 3. I was going to address, my lords, on my learned friend's formulation of the issue, which they set out in their grounds of appeal and in their skeleton argument, but I think that's no longer necessary. We say that formulation is wrong for the reason the judge gave at paragraph 44 of the judgment below. But I wonder if I might briefly address the formulation of the issue suggested by my Lord Justice Popplewell yesterday. That is taken from page 105 of yesterday's transcript. I record it as being whether the revenue rule bars SCAT from making a claim to compensation for Danish dividend tax refunds which it has mistakenly made as a result of misrepresentations.
Just give me the page of the transcript.
It's 105 of yesterday's transcript.
Yep.
We say, in response to that, and with the greatest of respect, that this formulation does not assist because it's too widely worded. As between SCAT and ED&F Man, Mr. Justice Andrew Baker did not decide that any claim that meets this description would be barred by Dicey Rule 3. He may well have expressed himself widely because he was dealing with a range of different claims against a range of different defendants. But the preliminary issue as between SCAT and ED&F Man did not concern other defendants or other claims made against those other defendants. The fact that Mr. Justice Andrew Baker did not decide an issue as wide as that formulated by my Lord Justice Popplewell yesterday may be illustrated with an example. Let's say that I misrepresent to SCAT that I am X, who is a genuine Danish taxpayer who is owed dividend tax refunds. Induced by my misrepresentation, SCAT pays me refunds in the mistaken belief that I am X. SCAT then seeks compensation from me for those refunds. And that is a claim in our respectful submission that fits my Lord Justice Popplewell's suggested issue. But in fact, Mr. Justice Andrew Baker expressly said in the Revenue Rule judgment that he was not deciding that issue. He did so at paragraph 90 of his judgment, which is at Bundle J, tab 2, page 45. And might I invite my lords to turn to that. That is on page J/2/45, where Mr. Justice Andrew Baker said this. In saying what he just said in paragraph 89, I put to one side misrepresentation as to identity, which it is not necessary to take a view to decide the present case. Mistakes as to identity can be seen as conceptually different to other errors, and a decision that Dicey Rule 3 applies in the present case does not have to mean that it would apply to a case where SCAT's claim was not founded on an allegation that it had made a payment to Party A, intending to pay a tax refund to which, in error, it had assessed Party A to be entitled, but on an allegation that it had made a payment to Party B, mistakenly thinking it was paying Party A, as it happens, intending to pay a tax refund to Party A. Claims for compensation as a result of mistaken identity do not feature in either the original claim or the current claim. But what that paragraph of the Revenue Rule judgment illustrates in our respective submission is that Mr. Justice Andrew Baker did not decide that any claim for compensation in respect of refunds paid out by mistake as a result of misrepresentations is barred by Dicey Rule 3. My lords, I've gone that last section at something of a...
I understand your point. Does that equally apply to Mr. Malick's formulation, which was put slightly differently, which it was applications conveying misinformation?
Yes. I think it would. And I think that Mr. Malick's formulation, I think, would, if I'm thinking of the right formulation.
Well, it was the one that came shortly after mine. It's on page 107.
Oh, right. Yeah, no.
Mine, I entirely take your point that mine would have encompassed an identification mistake or misrepresentation.
Yes.
But if you qualify mine or adopt his, which is that it's as a result of misrepresentations.
But I think my response to that...
comprising misinformation.
Yes, I think the misinformation would be whether I am X, a Danish taxpayer. It would seem to me to fall within it in the same way. I mean, I think that there's a bigger point here, which is the moment you start having to slice and dice precisely what the issue is that might have been decided and make exceptions here and brackets there, you're on a slippery slope. The way that is the problem with, we would respectfully submit, from approaching things from the wrong end. If you start with the claim that's been pleaded on the facts against a given defendant and work from that, you don't hit that sort of problem. If you seek to try and say, fundamental to all of this, there was a decision that goes outside of the facts of the pleaded case against ED&F, then you may have a difficulty in working out precisely how to formulate that issue and to formulate it in a way that in our respectful submission, needs to be made to square with everything that Mr. Justice Andrew Baker said.
Yeah, the point I was putting to Mr. Malick is, if you're claiming issue estoppel, you've got to start by defining the issue.
Yes.
So in a sense, that is where you have to start.
It is where you have to start. But as you know,
but I understand your point that you have to do it with sufficient precision.
Exactly.
That it doesn't admit of exceptions.
Exactly.
In relation to what the judge decided.
Yeah. So, forgive me, my lords. And I'm being reminded by those wiser than me that if there is any doubt as to the ambit of the issue, you can't find issue estoppel. Issue estoppel is a doctrine that requires precision and certainty. So unless your lordships have any more questions for me, that was all I was proposing to say about issue estoppel.
Thank you very much.
I will turn on to abuse of process, the second ground of ED&F Mann's appeal. And there are three preliminary points I would like to make here. First, with the exception of one point, which concerns the burden of proof, which I will come on to, the legal principles are common ground. My learned friends accept in their skeleton at paragraph 62, not going to take you there, C/3/33, that with one exception, the judge accurately set out the legal principles relating to abuse of process at paragraphs 50 to 58 of the judgment. At paragraph 85 of their skeleton, my learned friends also accept that the judge set out the ALDI guidelines correctly at paragraphs 59 to 63 of the judgment. Now, after the judgment below was handed down, this court has had occasion to consider the principles relating to abuse of process in the MW High-Tech Projects case, which was decided in July this year. And that decision is in the Authorities Bundle, Volume 3, at tab 26. And the judgment in that case was given by Lord Justice Coulson, with whom Lord Justice Arnold and Lord Justice Stuart Smith agreed. Lord Justice Coulson surveyed the authorities on abuse of process at paragraphs 31 to 52 of his judgment. My Lord's notes, that's A3/26/938 to 943. and he set out a summary of the key principles which he derived from that survey in paragraph 53, which starts at page 943 of the bundle. You should find on page 943 a section 6.4 summary of the applicable principles. And that paragraph 53 occupies the rest of the page and goes over just by a couple of lines onto the following page.
Yes.
And we note that the judge's articulation of the principle in his judgment below perfectly preempted Lord Justice Coulson's summary of them in this court just a few months later. The second preliminary point is that this court is generally reluctant to interfere with a first instance judge's decision on Henderson and Henderson abuse of process. That is because such a decision should be based on a broad merits-based assessment, in other words, an evaluative judgment involving the balancing of a number of different factors. It is common ground that this court will not interfere with such a decision unless the judge A, failed to take into account material factors, B, took into account immaterial factors, C, erred in principle, or D, reached a conclusion that was perverse or plainly wrong. That is stated in paragraph 52 of our skeleton, C/4/62, and in paragraph 63 of my learned friend's skeleton, C/3/33. The third preliminary point is that the judge below reiterated the note of caution sounded by many of the authorities on the topic of Henderson abuse of process, that this process should not likely be used to shut out a claimant from bringing a genuine cause of action. If I could ask you to pick up the judgment below, paragraph 55, that's C/6/81. Paragraph 55. You'll see there, well, can I just, again, for the interest of speed,
Yes,
can I invite you
yes.
to read that paragraph yourselves?
Yes.
The judge reminded himself that a claim must clearly be shown to be an abuse, and that a party alleging such an abuse faces a high hurdle. My learned friends do not say the judge was wrong about any of that. The high hurdle facing my learned friends is that they must show that Scatt's conduct has been so objectionable as to make it just that it should now be deprived of its rights to participate in a trial of its new claim. See also paragraph 122 of that judgment, that's on page 91, and the references there to the need for caution before shutting litigants out of their right to justice, in the light not least of the impact of Article 6 of the Convention. On burden of proof, my lords, I'll take this extremely briefly. My learned friend's first subground relating to abuse of process was on the burden of proof. My learned friend was content to rest on his written case as regards this subground. If I may, I will do the same. For your lordship's reference, we deal with burden of proof at paragraphs 56 and 57 of our skeleton. In summary, we say the judge's decision was not based on burden of proof, and in any event, we say the judge was right to say that, as a matter of law, the burden on establishing an abuse was on ED&F man throughout, albeit that the process has to be a broad merits-based one with evaluation made of a number of different points. My lord, that takes me to the second subground within ground 2 of the appeal, this is ground 2.2, from which my friends were given permission to appeal, is that the judge omitted to take into account material factors. In reaching his conclusion that Scatt's claim was not an abuse of process. So my lords note That is in the grounds of appeal in the core bundle, tab 1, at page 16, so C/1/16. But we would respectfully submit that it is apparent from my learned friend's skeleton argument that in fact their complaint is not that the judge failed to take into account these factors. Rather, their real point is they disagree with the judge's analysis of these factors or with the weight that he attached to them. That is a different complaint altogether. Can I just show, my lord, some examples of that? If we can start by picking up my learned friend's skeleton at paragraph 74, that's C, tab 3, page 35. And you'll see that section C4, beginning just below halfway of that page, is entitled Material Factors Not Taken into Account. Within paragraph 74, my learned friends seek to identify various factors that they say the judge failed to take into account. Those factors run from page 35 of the bundle until page 39. For example, in paragraph 74.1, on the page we're already looking at, C/3/35, they refer to certain letters that SCAT wrote to the Danish prosecutor on 24th of August 2016 and 3rd of May 2018. And then over the page in paragraph 74.2, they refer to submissions that SCAT made to the Danish tax tribunal. But if, having turned over to page 36, and if you're looking at 74.2, if I could then invite you to look just a little further down the page at 74.3, you will see that the first sentence of that paragraph gives the game away. My learned friends say there that the 2 points they've just identified in the 2 immediately preceding paragraphs are in fact, to use their words, touched on in the judgment at paragraph 71 sub 2. And in the remainder of that paragraph 74.3, they then say that the judge's analysis of those matters is wrong. If my lords would be kind enough to turn to paragraph 71 sub 2 of the judge's judgment, that's tab 6 of the same bundle, and we're looking at 84 and then over the page to 85, you will see in our respectful submission that these factors are more than touched on. The judge actually analysed them carefully. Going back to my learned friend's skeleton, my lords will see something similar going on in paragraph 74.4. That's C, tab 3, page 36. That paragraph refers to ED&F Man's admission in respect of Annex E tax vouchers in its amended defence and Part 18 response of September 2019. But by the time we get to the end of that paragraph, we see that my learned friends can't bring themselves to say that the judge did not take this factor into account. He plainly did. And again, my learned friends accept that the judge referred to this factor in the judgment at paragraph 71 sub 1. And again, that's the reference for that is C/6/84. So although my learned friends say the judge failed to take these factors into account, their real point is, they say, the judge's analysis of these factors is incorrect. Your lordships may have seen that my learned friend's submissions under this subground run from paragraphs 74 to 81, which are paragraphs 35 to 41 of the core bundle. And those submissions are, in substance, an attempt to re-argue the case that they had argued before the judge, and which he rejected. In the context of this appeal, that poses a problem for my learned friends. That is because, in the context of an appeal from the judge's decision as to abuse of process, it is not enough for my learned friends to say that the judge's analysis was wrong. They have to establish either that he failed to take into account material factors, or that the judge's decision on abuse overall was plainly wrong or perverse. And we respectfully say that my learned friends do not come anywhere near to showing either of those things. We would remind the court will not be surprised to hear, that the judge was provided with more than 80 pages of written submissions, 3 days of oral argument, more than 150 pages of witness statement, and about 5,000 pages of evidence by way of exhibits. It would have been humanly impossible for any judge to mention in the judgment every single one of those submissions and every single piece of evidence. So the fact that the judge does not do so does not mean that he failed to take into account those submissions or that evidence. And in this context, in paragraph 60 of our skeleton, we refer to this court's judgment in the NatWest Markets against Bilter case, where this court explained that a judge is not required to address every single point in a judgment, and that a judgment given in a timely fashion can be assumed to have been prepared with a full recollection of the relevant evidence. For my Lord's notes, I think it was a case that Mr. Temple took you to yesterday, but I'm talking about paragraph 96 of the judgment in that case, which is at Authorities Bundle, Volume 3, tab 22, page H21. I'm very happy to go there if you'd like.
I suspect that we sufficiently remember. Yes.
Very good.
That's the only paragraph in that authority which you rely on.
Yes. That reasoning applies with particular force to the judgment under appeal because, as you heard yesterday, the hearing before the judge concluded on Thursday the 25th of Thursday the 25th of January 2024, and the judge circulated a draft judgment to the parties on Monday the 29th of January 2024, with judgment being handed down the following Friday the 2nd of February. It follows that this judgment was prepared while the judge had fresh in his mind the submissions and the evidence. So there is simply no proper basis in our respectful submission for this court to find that the judge failed to take into account any of the factors that my learned friend relies on. I'm not going to go and deal in detail with any of the points made in paragraphs 74.1 and 74.4 of my learned friend's skeleton to explain why what the judge has to say about them is well-founded. There isn't time. But as for the other factors they rely on, the judge plainly took into account the factor referred to at paragraph 74.5. That is the one that begins at the bottom of C/6/36 and goes over the page to 37. The judge's analysis at paragraph 71.2, which we've already looked at, covers not just points taken by SCAT in Denmark, but points taken in other countries as well, and that would include the USA. The US proceedings are also taken into account by the judge at paragraphs 82 to 86 of the judgment. That is those are to be found on page 86 behind tab 6. The factors referred to by my learned friends of paragraphs 74.6 to 74.8 of their skeleton all relate to what my learned friends say SCAT should have learned from particular documents contained in the vast quantity of disclosure, some 182,000 documents, given to it by ED&F Man. The judge considered what SCAT should have learned from that disclosure and when, and he did so in considerable detail. For that, your lordships need to look at paragraphs 72 to 81 of his judgment. And picking that up, you can see that that begins, that's on page 85, and goes over to page 86. The factor referred to at paragraph 74.9 involves a straightforward misreading of the correspondence referred to. There is a world of difference between SCAT solicitors saying in a letter that we will infer fraud in the absence of an innocent explanation, and SCAT filing a formal pleading before the English court, making an allegation of fraud signed off by counsel. It is clear from the transcript that the judge thought that there was nothing in this point. Again, I'm not going to take you to the transcript, but it's day 3, pages 124 to 125 and 128, and the reference for that is S1/5/102 to 103. So we would say it's clear from those transcript references that the judge was firmly of the view that there was no substance in my learned friend's reliance on those letters. First, because writing a letter to the other side and pleading fraud in a formal pleading before the English court are two different things. And second, because what was being said in those letters is not the basis for and is inconsistent with what SCAT now pleads in the current claim. The factor referred to in paragraph 74.10 of my learned friend's skeleton again involves the misreading of the content and the purpose of the document in question, this time a draft statement of agreed fact. My learned friends also ignore the fact that this draft was sent out in April 2021, so after the end of the Revenue Rule trial, and so it comes too late to be relevant anyway. In relation to all these factors, the judge was entitled to prefer, as he did, the evidence of Miss Craven, and for that you need to see his judgment at paragraphs 83 to 85 and 87 to 90. That is C/6/86 to 87. The judge was also entitled, in our respectful submission, to accept SCAT's submission that parties before the English court are encouraged, indeed required, to be reticent about alleging fraud, which is a point I shall turn to next. All in all, my learned friends cannot establish that the judge failed to take into account any material factor in the sense required to give rise to an abusive process. So the further point I wish to make about this ground of Eden F. Mann's appeal relates to a number of points that my learned friends make under this heading, which we've touched on statements made by SCAT in letters it wrote to investigating authorities, or on submissions made by SCAT in other countries, in other procedural contexts. Paragraph 71.2 of the judgment, or 71(2) of the judgment, the judge rightly rejected those submissions on the basis that such conduct is not the same thing as pleading an allegation of fraud in civil proceedings that are governed by the pleading rules in this jurisdiction. The judge came back to this point at paragraph 88 of the judgment below. Might I invite my lords to have a look at that passage? It is on page 87 of the bundle, again behind tab 6. Paragraph 88, near the top of that page, Mr. Justice Bright said this: Mr. Graham KC said in submissions that the court should have in mind that parties and their lawyers are entitled to be reticent about alleging fraud, and that in technical cases like this, they may take the view that fraud should only be pleaded with the support of a suitable expert. He further said that I should have in mind that the views of practitioners vary. Some are gung-ho about pleading fraud, others are more cautious. I should assess what SCAT should have done by reference to the more cautious end of this spectrum. And then in the first few words of paragraph 89, the judge said he accepted that submission. The reference to the parties and their lawyers being entitled, and indeed required, to be reticent about pleading fraud is reflected in a judgment of this court, which the judge had referred to at paragraph 65 of the judgment. And of course I'm referring to this court's decision in the Playboy Club case. That's in the Authorities Bundle, volume 2, tab 20. And I wonder if my lords could please turn that up. The facts are set out in the head note, which you should have on page A724. But in very brief summary, the claimant club had previously brought a claim for negligent misstatement against the defendant bank based on a credit reference that the bank had provided in respect of a gambler called Mr. Hassan Barakat. That claim was unsuccessful following an appeal to the Supreme Court. The claimant bank then brought a deceit claim against the bank based on the same credit reference. The question is whether that second claim was an abusive process. And might I invite your lordships to look at paragraph 3 of the judgment of Lord Justice Sales, at page 91 of the report, page 725 of the bundle. Picking it up at paragraph 3, Lord Justice Sales says, the club accepts that a claim in deceit in relation to the credit reference could properly have been included in the action by which the negligence claim was brought. However, it submits that on the material available in advance of the trial in that action, it would have been a speculative and weak claim in deceit, albeit one which could properly have been advanced. And, given the particular responsibility on counsel and a party in relation to pleading fraud, it cannot be said that it was incumbent on the club to include a deceit claim in that action. So, my lords, this was a case in which it was common ground that the new claim could have been pleaded earlier. The only question was whether it should have been. And a key passage in Lord Justice Sale's reasoning is at paragraph 46. That is at page 101 of the report, page 735 of the bundle. Picking it up, beginning of paragraph 46, although a deceit claim could have been introduced by the club alongside the negligence claim before the trial of that action, it cannot properly be said that such a deceit claim should have been so introduced, i.e. on pain of losing any later opportunity to plead a case in deceit, no matter what further evidence pertaining to fraud might emerge. The pleading of fraud or deceit is a serious step, with significance and reputational ramifications going well beyond the pleading of a claim in negligence. Courts regard it as improper and can react very adversely where speculative claims in fraud are bandied about by a party to litigation without a solid foundation in the evidence. A party risks the loss of its fund of goodwill and confidence on the part of the court if it makes an allegation of fraud which the court regards as unjustified, and this may affect the court's reaction to other parts of its case. And then there's a reference to observations made by Mr. Justice Burse in the Property Alliance Group case, where he says allegations of fraud can cause a major increase in the cost, complexity and temperature of an action. For these reasons, continues Mr. Lord Justice Sales, for these reasons parties are well advised and indeed enjoined, according to the usual pleading principles, to be reticent before pleading fraud or deceit. Although the club could have pleaded deceit before the trial of a negligence claim, in my view it behaved reasonably and entirely properly in deciding not to do so on the speculative and inferential basis which would have been necessary at that stage. And that is where the judge's reference in this case to the need to be reticent before pleading fraud perhaps comes from. And one aspect of Lord Justice Sale's reasoning in that passage is that the fact that English pleading rules require parties and their lawyers to be reticent before pleading fraud is an important factor to be taken into account in assessing whether a claim alleging fraud against ED&F Man should have been brought earlier. I refer to that judgment to make this point, that the judge was right to say the fact that SCAT or its lawyers had written letters or other documents in which various factual suppositions or allegations were made does not mean that it would have been proper for English counsel operating under their professional rules and under English pleading rules to plead fraud in civil proceedings before the English High Court. Those are two very different things, and the judge rightly considered that they were different things. And so we submit to your lordships that this was a further material factor that affected both when SCAT could and should have raised a fraud claim. In paragraph 66 of his judgment, Mr. Justice Bright referred to the Playboy Club as illustrating not only the difference between could have and should have in this context, but also the importance of the underlying facts to making an evaluative judgment as to when a fraud claim could and should have been raised. And of course you will already have in mind the judge's comments that it was not until SCAT had seen the entirety of the disclosure and had had the entirety of that disclosure looked at or seen it in the light of expert evidence relating to these complex trading structures, that it would have been right to plead fraud.
I mean, he says in paragraph 90, having referred to Mr. Wade's first report, first weeks of January 2022, this is when SCAT first could have pleaded fraud.
Yes.
That seems a bit more surprising. But you say, well, even supposing that it could have pleaded earlier, that doesn't mean it should have done.
Exactly. Not least because, obviously, in January 2022, the claims against E&F Man were still struck out.
Well, that is
So,
followed that fighting.
and
That
the
would have made
judge,
it quite hard to plead.
yeah,
Yes.
the judge makes the point that there was no need to look at all of this
Yes.
until after the Court of Appeal's decision, and then one then goes and sees how quickly after that the claim could have been made.
Yes.
So
Why were you still getting disclosure? Did all disclosure come before
the disclosure, my lords, came in a number of tranches. This was touched on yesterday. All the A trades, that is the trades from the seller, under which the seller contracted to sell shares to the EDF Man's pension plan client, they were disclosed in, I think, tranches 2 and 3. I could be wrong on the exact tranche numbers. In order to understand what's going on, you need to marry up the A trades with the B trades. Now, the B trades were spread piecemeal throughout the entirety of the first 8 of the 9 tranches of disclosure. And there's a helpful chart in Miss Craven's witness statement. It's worth taking you to just very briefly. That's S2, tab 38. And one wants to look there at page 464, I think it is. 465, rather. It's under paragraph 89, which starts on page 464. What Ms. Craven is doing there is analysing the 4th to 9th tranches of disclosure given, and she gives the dates. And then she refers also to the documents evidencing the B trades.
Yes, I see.
And she says, picking it up at the very bottom, the trade packs in the 2nd and 3rd tranches of disclosure only contain information about the A trades, i.e. transactions under which the PP clients purported to purchase the relevant shares from EDFM Dubai or other sellers. They did not include information about the B trades, i.e. trades under which sellers of such shares purported to cover their short sales by buying back from the pension plan clients an equivalent number of the same shares that they had purported to sell to the pension plan clients in the first place, but which the sellers did not own. Documents evidencing the B trade were spread throughout the various tranches of EDFM's disclosure. I demonstrate this in the table below by reference to 6 examples of B trades, 3 of which form part of Annex E cum-ex trades, and the other 3 of which form part of non-Annex E cum-ex trades. And you see there on page 465, the first trade, Annex E trade, has got 5 entries, and the B trades relevant to the documents come in the 8th tranche, the 6th tranche, the 2nd tranche, the 6th tranche, and the 8th tranche. And then so far as the 2nd trade is concerned, you've got all those references to the left and in the central columns. The B trades are being disclosed in the 8th tranche, the 5th tranche, the 5th tranche, the 8th tranche. 3rd, you go on through page 466. You can see that throughout that table, it is impossible to know where you've got the B trades until you've had all the disclosure, even though there weren't in fact any B trades disclosed in the 9th tranche. But you've got to have the entirety of that, and then you've got to have someone with a very cold towel, or perhaps more than one person with a very cold towel, sit down and go through them and marry those B trades up with the A trades. Before you need to do that, you need to know from someone who understands about the way this works why the fact that certain trades are shown as being back to back with the A trades have the effect of saying this never was effective to transfer any shares.
And when was the disclosure complete?
Completed on the Friday before the revenue rule trial began on the Monday.
So people were quite busy preparing for the revenue rule.
They were quite busy preparing for the revenue rule trial. As it happens, their hard work did not obviously pay off. But the point is that the 9th tranche was produced on Friday, the 19th of March, 2021, with day 1 of the revenue rule trial starting on Monday the 22nd of March.
And was it then reasonable to wait until the outcome of the revenue rule trial before putting the cold towel around your head, or should you be getting on with it?
Well, I think there are. We would say, my lord, it's no surprise that all hands were to the the pump that was the revenue rule trial, and then the judgment from that came out very soon thereafter.
Well, it came out at the end of April.
End of April, exactly. But it wasn't until we got Mr. Graham Wade's report, which was dated the 31st of December 2021, that we were in a position to understand what it was we were looking at. What was how the A trades and the B trades interlocked with one another, and why they had the effect that they did. Remember, my only friend Mr. Malik took you to that little chart, and once you start seeing that there's a pattern with certain trades where the PP client is the buyer happening on the reference date or the dividend declaration date, and then actually, if you look, in every case there's a sale going on the next day by that pension plan client back to somebody else. You can't immediately tell whether it's back to the same seller because it's all done through brokers. So all you see is the name of a broker, and you don't know whether the same seller will be on the other side of that trade. So you need to do that in our respectful submission. And I'm being reminded that I should show your lordships paragraph 80 of the judgment below.
Just before,
yes.
Perhaps while you're doing that, does Miss Craven say in terms where we couldn't understand how it fitted together till we saw Mr. Wade?
Yes, she does.
Yes,
that's paragraph 103 of her witness statement.
Yes.
Well, it's quoted by the judge at 84.
Yes,
but it's a bit more than that, isn't it? Because as was pointed out, that passage is talking about an understanding of the and it is all the documents disclosed in the judicial proceedings.
It was one of the points I was going to make if I hadn't trimmed.
Yes.
Was the suggestion that 103, Craven 103, was not all-encompassing, was not a convincing one.
No, and that's why at 87, the judge also refers to Miss Craven's evidence that 31st of December 2021 was when SCAT began to understand the position.
Exactly so. So that's why at 90 he says it's when SCAT first could have pleaded fraud. Yes. So his conclusion on the evidence that was before him was that SCAT could not have done that before a period of time after receipt of Mr. Graham Wade's report, and he then says in paragraph 93, he says, "I do not know whether SCAT had in fact decided to bring a fraud claim against the ED&F man by the time of the Court of Appeal hearing." So he is suggesting it should have been done within days or weeks of getting that report. But I mean, I think we would say, once you understand the principle involved, you've then got an awful lot of documentation to go through, and you've got to get that documentation in front of counsel, and counsel have got to say, yep, that works for me. I'm prepared to put my name to that. That doesn't happen overnight. And Ms. Craven has also said that it was actually it was shortly before the CMC hearing in front of Mr. Justice Andrew Baker on the 6th of May 2021 that it was reckoned that a fraud claim could be pleaded, and the reason why there's the Aldi point that there is because the judge felt that the way in which the fact that there might be a fraud claim was notified to Mr. Justice Andrew Baker for the purpose of that claim was not in sufficiently clear terms. But I'm concerned I may be trespassing on territory I've very much said I would carve out and leave to somebody else. So
you said 6th of May 2021, but I thought it was not until May 2020.
Sorry, I misspoke. It is the way Graham Wade expert report, 31st December 2021,
Yes.
and then Court of Appeal hearing 25th to 27th of January 2022, and then the CMC hearing is the 6th of May 2022. You're absolutely
Was it the 11th of May?
sorry.
11th of May?
11th of May. I'm so sorry. No, I had the 6th of May.
Well, the judge also says that until you get the Court of Appeal judgment, you don't have any reason to consider
No.
fraud
Exactly.
against, or consider the disclosure any further, because your claims are dead. All of them,
Yes,
subject to appeal.
subject to appeal.
So do you down tools on the disclosure exercise and the analysis while you're waiting for the Court of Appeal's judgment, or do you carry on anyway?
Well, I would have to work within the four corners of
What's been disclosed?
Ms. Craven's witness statement.
Yes.
I'm afraid I wasn't then on board,
Yes.
but I came in sort of after that. But it wouldn't surprise me if there was a different pitch of the level of work being done once the Court of Appeal decision had come out. That would be logical, but I don't know one way or the other whether that's the case. What I think we have to work with is what's in our respectful submissions in Ms. Craven's witness statement,
Yes.
and the weight that the judge attached to that, which we say he was perfectly entitled to do. I've been shown a passage from Ms. Craven's witness statement, which is paragraph 82, which is S2/38/463, where she's referring to the court's draft judgment arising from the revenue rule trial. So we're going back to 2021. This is, as you will recall, the hearing in respect to the revenue rule issue began on the 22nd of March, and I think it finished by the 25th of March. And Ms. Craven says here at paragraph 82, top of the page, the court's draft judgment arising from the revenue rule trial was circulated on the 19th of April 2021, and there's a reference to an exhibit. In view of the decision of the Commercial Court to dismiss all of SCAT's claims, including those against EDFM, the review of EDFM's disclosure was stopped in April 2021.
Yeah.
And while we're looking at Ms. Craven's witness statement, I'm aware that we've been given a confidential bundle and there are redactions to the witness statements. Is that something we need to concern ourselves with?
I don't think so, my lord. The confidentiality regime arises out of US proceedings, where certain documents are, I think, have been, or certain references to certain parties and certain documents have been designated confidential. My own view of the matter was that I didn't need to take your lordships to any of them, and it would get in. There was to say I was predisposed to reach that view would perhaps be putting it too strongly. So I don't need to take you to the X bundle. The X bundle does contain various references. If you come across something in the S bundles which are blacked out, the relevant the relevant full text will be in the
But none of your submissions.
None of my submissions depend on you looking at the X bundle.
Thank you.
As I was submitting, looking at paragraph 66 of the judge's judgment, he says in relation to the Playboy Club case, it illustrates the difference between could have and should have. It also illustrates the importance of the facts, and that is the importance of the facts before being able to plead a case in fraud. It's very obvious. You've got to make sure that you're completely across the facts before you're able to do that. And these, of course, were the facts here were facts that, as it were, had to be fitted into what I think can certainly be called, with confidence, very complex trading structures. So they all needed to be understood. In the judge's reasons for refusing permission to appeal, he went on to say, he made a specific reference to that paragraph. Let me show you. It's behind tab 8 of the core bundle. At page 97. And obviously we're looking under item 2, Henderson and Henderson abuse. My decision turned on the facts, CF judgment 66, and that's a reference there to the importance of the facts before pleading a claim in fraud, and I've made already my submissions as to how complicated the facts potentially were, and my conclusion as to when SCAT both could and should have raised a fraud claim. I took all of MCML's, that's EDFM's, points onto this into account. They're not sufficient to gainsay SCAT's evidence from Miss Craven, judgment 82 to 87, and the points made in submissions and accepted by me as regards the need for expert input, judgment at 88 to 89. They were taken into account in the conclusion at 90 and 91. My Lord, that brings me to my learned friend's ground of appeal 2.3. And this ground is the ground that the judge erred in finding that EDF Man has not suffered any prejudice as a result of SCAT's failure to bring the current claim in earlier proceedings. Now, my lords, the judge devoted a substantial section of the judgment to considering the issue of what prejudice EDF Man might have suffered, and he dealt with it in paragraphs 100 to 117 of the judgment. And for my lord's notes, that's C/6/88 to 91. I won't attempt to take your lordships through all of those paragraphs, but I will, if I may, show your lordships a couple of key passages. Can we just look at the heading above paragraph 100 of the judgment? That's core bundle tab 6, page 88. You see there the heading is, what difference would it have made? And the judge is analysing here what would have happened if SCAT had brought the current claim in the earlier proceedings. And the three key paragraphs here are paragraphs 104 to 106 on page 89. Can I invite you to read those very quickly? In summary, therefore, the judge held there that whether the current claim was heard as part of the earlier proceedings or as a freestanding claim, the same issues would arise between SCAT and EDF Man. Second, that if the current claim had been heard as part of the earlier proceedings, those issues would have been heard and decided in hearings which would have involved a host of other parties. That would not be the case if the current claim were heard separately. And then at paragraph 106, the judge made the point that even if the current claim were brought separately, there would need to be no relitigation of previously decided issues. And that is a point I'll come back to. At paragraph 116 of the judgment, which is on page 91, the judge expressed the conclusion that this is not a case where there has been any harassment or oppression of the EDF Man. And at paragraph 117, he said this, on the contrary, like many defendants, EDF Man seemed to be content for the case against it to proceed slowly. He then refers to two examples of such conduct on the part of EDF Man in the first two subparagraphs of that paragraph. And then in the final subparagraph, subparagraph 3, he says, I infer that EDF Man is not unhappy that the fraud claim against it will probably not be determined until after the main trial. And finally, in the concluding section of the judgment below, Mr. Justice Bright weighed against each other any prejudice that EDF Man might suffer against the prejudice that SCAT would suffer if its claim was struck out. And on that topic, may I please ask my lords to remind yourselves of what the judge said as part of his conclusion in paragraphs 120 to 123 of the judgment. That should be the page you already have open.
Yes.
It's from, however, this is not a case, at paragraph 120, down to the bottom of the page.
Yes.
Thank you. So, on a quick overview of prejudice, my learned friends say the judge was wrong to find that ED&F man would not suffer any prejudice as a result of SCAT's failure to bring the current claim in earlier proceedings. But it is not enough, in our respectful submission, for my learned friends to say the judge was wrong to find that ED&F man would not suffer any prejudice. They do not challenge the judge's articulation of the principle that usually, in order to strike out a claim on the basis of abuse of process, there must have been unjust harassment or oppression of the applicant. And the judge stated that principle in paragraph 56 of the judgment. That's C /6 /81. Further, whether ED&F man would suffer such prejudice and what impact it should have in the broad merits-based assessment as to whether there has been an abuse of process are factors that the judge plainly had regard to. As I mentioned earlier, he dealt with those points in detail in the judgment. He also weighed them against the prejudice that SCAT would suffer if its entire claim was struck out. So in order to succeed on this aspect of their appeal, my learned friends have, in our submission, to persuade the court that as a result of the judge's approach to the issue of prejudice, the balance he struck between the prejudice to ED&F man and the prejudice to SCAT was perverse or plainly wrong. And we say they do not even attempt to do that. We've responded to the points in my learned friend's skeleton argument on prejudice, the points they make at paragraph, I think it's 83. We've responded to those at paragraph 63 to 69 of our written skeleton. And beyond drawing those references to my lord's attention, I was not proposing to say much more on that. I was proposing to deal with one issue, though orally, and that is the point that my learned friends make, that the judge failed to apply the rationale for Henderson and Henderson abuse, namely that a party should not be twice vexed in the same matter. That is in their skeleton at paragraph 83.1, that's C/3/42, and they cite in support of that proposition Lord Bingham's speech in Johnson against Gore Wood. And the judge reproduced the relevant passage from Lord Bingham's speech at paragraph 50 of the judgment. That's on page 79 of the bundle. It is a passage, I'm sure, with which your lords will all be familiar, but it is worth looking at. If one can I invite you, looking at that section, to pick it up about 6 lines down, beginning with "but Henderson and Henderson abuse of process." But Henderson and Henderson abuse of process is now understood, although separate and distinct from cause of action estoppel and issue estoppel, has much in common with them. The underlying public interest is the same, that there should be finality in litigation and that a party should not be twice vexed in the same matter. The public interest is reinforced by the current emphasis on efficiency and economy in the conduct of litigation, in the interests of the parties and the public as a whole. The bringing of a claim or the raising of a defence in later proceedings may, without more, amount to an abuse if the court is satisfied, the onus being on the party alleging abuse, that the claim or defence should have been raised in the earlier proceedings if it was to be raised at all. I would not accept that it is necessary, before abuse may be found, to identify any additional element, such as a collateral attack on a previous decision or some dishonesty. But where those elements are present, the later proceedings will be much more obviously abusive. And there will rarely be a finding of abuse unless the later proceeding involves what the court regards as unjust harassment of a party. It is, however, wrong to hold that because a matter could have been raised in earlier proceedings, it should have been, so as to render the raising of it in later proceedings necessarily abusive. That is to adopt too dogmatic an approach to what should, in my opinion, be a broad merits-based judgment which takes account of the public and private interests involved and also takes account of all the facts of the case, focusing attention on the crucial question whether in all the circumstances a party is misusing or abusing the process of the court by seeking to raise before it the issue which could have been raised before. As one cannot comprehensively list all possible forms of abuse, so one cannot formulate any hard and fast rule to determine whether, on given facts, abuse is to be found or not. And breaking off there, my lords, what Lord Bingham was saying in that passage is that one aspect of the public interest underlying the abuse of process principle was that a party should not be twice vexed in the same matter, meaning, we would respectfully submit, that it should not without more have to relitigate an issue or issues in successive trials or hearings. What Lord Bingham did not say is that there is any rule of law that any time a party was sued more than once in relation to the same or similar matter, that would constitute an abusive process. The fact that Lord Bingham was not saying that is apparent from the closing part of that passage I read out to you, where he cautioned against taking too dogmatic an approach to what should be a broad, merits-based judgment which takes account of the public and private interests involved and also takes account of all the facts of the case. So it is not sufficient for my learned friends to say that Edian Man is being sued twice in respect of the same tax vouchers. That does not by itself establish abuse of process. Your Lordships may have seen in paragraph 64b of our skeleton that we cite the guidance of this court in Michael Wilson and Partners against Sinclair for the proposition that there is no prima facie assumption that bringing new proceedings in relation to issues that have been decided in earlier proceedings is abusive. The judge cited the same case for the same proposition, paragraph 54 of the judgment. That is C/6/80. Again, I'm not going to read that out to you unless your Lordships would like me to.
No.
My Lords, you have heard more than enough from me, and I would now like you to hear briefly from Mr. Krishna Prasad, who is going to deal with the Aldi guidelines.
Mr. Krishna Prasad.
My Lords, the final subground of Edian Man's appeal is that having found that SCAT had breached the ALDI guidance, the judge should also have found that SCAT's current claim is an abusive process. My Lords, may I identify first of all what is not in dispute? SCAT does not challenge the judge's finding that SCAT breached the ALDI guidance. However, my learned friends accept that a breach of the ALDI guidance by itself does not mean that a new claim will automatically be struck out. That is in paragraph 85 of my learned friend's skeleton. It is also common ground that a breach of the ALDI guidance is one of the factors that the judge had to take into account as part of his broad merits-based assessment. That is also in paragraph 85 of my learned friend's skeleton. And in this case, the judge plainly did take that into account. So the only question that remains for this court is whether the judge's overall evaluation as to abuse of process was perverse or plainly wrong on account of the fact that he attached insufficient weight to SCAT's breach of the ALDI guidance. And we respectfully submit that the answer to that question is no. And if I may, my Lords, I propose to focus on four aspects of the judge's reasoning in support of that submission. The first aspect is the relevance the judge attached to the lack of prejudice that Edian Man has suffered as a result of SCAT's breach. My Lords, at paragraph 59 of the judgment, this is at page 81 of the bundle, the judge said that neither side had drawn his attention to any case in which a claim had been struck out on the basis of Henderson and Henderson abuse merely because a claimant failed to comply with Aldi's clause in circumstances where there was no element of harassment, oppression, unfairness, or some kind of prejudice. And then over the page, in the 4 sub-paragraphs of paragraph 59, the judge explained how that analysis applied to each of the 7 cases that had been cited to him on the topic. My learned friends don't say that the judge's analysis of any of those cases is inaccurate, nor do they say that he was wrong to attach the relevance he did to the lack of prejudice suffered by EDNF man. As your lordships know, in this case, the judge found that EDNF man had not suffered any prejudice as a result of SCAT's breach of the Aldi guidance. And your lordships have heard submissions from Mr. Graham as to why we say the judge was right to reach that conclusion. The second aspect of the judge's reasoning we rely upon is his assessment of the seriousness of SCAT's breach. The judge explained that in his ruling on cause. May I invite your lordships, please, to look at that ruling, which is in the core bundle at tab 7. And may I invite your lordships to look at paragraph 3, which is at page 94. In the interest of time, I won't ask your lordships to read that whole paragraph, but your lordships will see in lines 4 and 5 the judge's observation that the comment that was made to Mr. Justice Andrew Baker was at any rate better than silence, and it was not evasive. And in the last 2 lines of the same paragraph, the judge's comment that I suspect that this is a situation where there was a failure of efficient communication as opposed to anything more sinister or more cynical. So that's the judge's assessment as far as what SCAT said to Mr. Justice Andrew Baker is concerned. Now, as far as the position before this court during the revenue rule appeal is concerned, there are 2 points I should make very briefly. The first is just to remind the court that the judge did not find that SCAT had decided to bring a fraud claim against EDNF man by the time of the revenue rule appeal hearing before this court. Yesterday, Mr. Malik took your lordships to paragraph 92 of the judgment. That is at page 87 of the bundle, but we would respectfully suggest that what the judge said in that paragraph ought to be read in the light of what he went on to say at paragraph 93. And your lordships will see in the first sentence of paragraph 93, the judge said, I do not know whether SCAT had in fact decided to bring a fraud claim against EDNF man by 25th to 27th January 2022. Those are the dates of the hearing before this court. And he went on to say, SCAT, unsurprisingly, has not waived privilege over the decision-making process, etc. The second point I wanted to make in relation to the position before this court arises from a point that my Lord Justice Nuji made to Mr. Malik yesterday, which is, what difference would it have made if SCAT had told this court during the revenue rule appeal hearing that it was considering bringing a fraud claim against EDNF man? Now, Mr. Justice Bright's answer to that question is at paragraph 107 of the judgment. That is at page 89 of the bundle. In the second line of that paragraph, the judge said this would have had no bearing on the outcome in the Court of Appeal. And then he went on to say in the rest of the paragraph, the point would have been canvassed in correspondence between the parties and ultimately considered at the CMC before Mr. Justice Andrew Baker on the 11th of May 2022. So in short, we say that the judge's assessment was that although he found that SCAT had breached the Aldi guidance, this was not a breach that fell at the higher end of the spectrum of seriousness. May I then deal with very briefly the third aspect of the judge's reasoning that we rely upon, and this concerns the conduct of the party alleging the breach, which in this case is ED&F Man. And in this regard, may I take your lordships back to the judge's ruling on costs, which is in the core bundle, tab 7. Your lordships have looked at paragraph 3 already, and your lordships will recall that Mr. Graham took you to paragraph 117 of the judgment, where the judge made the comment that ED&F Man was not unhappy that the fraud claim against it would not be tried until after the main trial. He made some further observations along the similar lines at paragraph 5 of the ruling on costs, which is at page 95 of the bundle. Again, I won't ask your lordships to read that whole paragraph, but in the third line, your lordships will see the reference to ED&F Man's response to that was, as I've said in the judgment, somewhat leisurely. The judge then said the timing, I infer may, I put it no higher than that, may have been calculated to ensure that nothing happened very fast. Certainly there seems to have been a degree of festina lente in evidence, and in the last 3 lines, it is not a good policy for someone who wants to accuse the other party to litigation of delaying. It is poor tactics. So in short, the judge took a poor view of ED&F Man's conduct once the new claim had been brought to the attention of ED&F Man and to the attention of the commercial court. And the last aspect of the judge's reasoning that we rely upon is the balance he struck between the prejudice that ED&F Man would suffer if the current claim were to proceed and the prejudice that SCAT would suffer if the entirety of the claim were to be struck out. And again on that, Mr. Graham has taken your lordships through the concluding passages of the judgment, and I won't do that again. But may I just make one further point, which is this. The judge's reasoning on this topic, my lords, is supported by the decision of this court in the MW High-Tech Projects case, which Mr. Graham referred to earlier, although that decision was delivered after the judgment below was handed down. And perhaps I can just show your lordships just 1 or 2 passages from that judgment. It is in the authorities bundle at volume 3, tab 26. My lords, the facts are summarized in paragraphs 3 to 11 of Lord Justice Coulson's judgment. I won't attempt to reiterate them, but at paragraphs 38 to 49 of the judgment, there is an exhaustive survey of all the key authorities on the ALDI guidelines. And then at paragraphs 51 and 52, that is on page 943 of the bundle. There are 2 paragraphs, if I may I ask your lordships please to read those 2 paragraphs yourselves, paragraph 51 and 52. So Lord Justice Coulson said in those paragraphs that when there has been a breach of ALDI guidelines, the court takes into account factors that are similar to the 3 stages of the Denton test, and the application of those to the facts in that case, in particular in relation to the overall position of the parties, is at paragraphs 97 and 98 of the judgment, page 949. Again, in the interest of time, I won't ask your lordships to read all of those passages, but if I may just summarize what we rely on this case for. We say that this case supports the judge's analysis in 2 respects. First, in relation to the weight that the judge placed on the lack of prejudice that ED&F Man would suffer. And that is a point that Lord Justice Coulson repeatedly came back to, including at paragraphs 73, 97, and 102 of the judgment, And second, in recognizing that even when there has been a breach of the ALDI guidance, striking out a genuine and substantial claim is a draconian sanction. Those were Lord Justice Coulson's words at paragraph 98 at the bottom of page 949, and the judge used exactly the same language at paragraph 63 of the judgment below. My lords, may I now respond very briefly to two specific points that my learned friends make on this subground. The first of those points is that SCAT's breach of the ALDI guidance has had an adverse effect on the commercial court's time and resources. Now, the judge made that finding at paragraph 115 of the judgment below, and we don't challenge that. But it is clear that the adverse effect that the judge had in mind was the fact that Mr. Justice Andrew Baker was not given the opportunity to investigate all possible case management solutions. That is what the judge said at paragraph 111 of the judgment at page 90. But in terms of the practical effect of SCAT's breach on the commercial court's time and resources, the judge found that even if SCAT had followed the ALDI guidance, it was not possible to say whether the claims brought by SCAT against ED&F Man would have been tried as part of the main trial anyway. That is at paragraph 110 of the judgment. In the first sentence of paragraph 110, the judge said, "It is not possible to say whether Mr. Justice Andrew Baker could or would have made directions intended to enable the new claim against ED&F Man to form part of the main trial involving the other defendants." So in this case, even if SCAT had complied with the ALDI guidance, it is entirely possible that the commercial court's time and resources would have been taken up by a separate trial between SCAT and ED&F Man in any event. Anyway, we say that instead of striking out the claim, the judge was entitled to reflect any impact on the commercial court's time and resources in the cost order that he made, and that is what he in fact did. The judge deprived SCAT of the entirety of its costs of the application, although SCAT was the successful party overall, and the judge did not even award SCAT any of its costs of the issue estoppel point, even though, of course, any breach of the ALDI guidance was irrelevant to that point. For your Lordship's note, that is in paragraph 4 of the judge's order, which is in the core bundle, tab 5, page 71. And we would submit that the judge's approach of not striking out a claim and instead reflecting the court's disapproval of a litigant's conduct in the cost order is well supported by authority, including the decision of this court in the Otcriti case. We don't need to turn it up, but that decision is in the authorities bundle, volume 2, tab 18. And in that case, this court held that the first instance judge in that case, Mr. Justice Knowles, had been right not to strike out the claim and instead make an adverse cost order against the claimant who had breached the ALDI guidance. For your Lordship's note, the key paragraphs are 8, 53, and 64. May I then deal very briefly with one other point that my learned friends make. This is in paragraph 86 of their skeleton, and Mr. Malik also made the point orally yesterday. And it is that SCAT failed to put its cards on the table. My lords, that could mean one of two things. If what's being said is that SCAT failed to lay out its cards in front of the court, then I would respectfully suggest that it adds nothing to the point that SCAT breached the ALDI guidance, and we don't challenge the judge's finding as to that. But if what's being said is that SCAT failed to lay out its cards in front of ED&F Man, I would respectfully submit that there is no merit in that point. Your Lordships will recall that yesterday, Mr. Malik took you through a number of letters in which SCAT's solicitors were open with ED&F Man, that SCAT was considering the possibility of alleging fraud against ED&F Man. And based on those letters, among other matters, EDNF man submitted to Mr. Justice Andrew Baker at the Revenue Rule Consequentials hearing that SCAT was, I quote, pointedly reminding EDNF man of the possibility of the case against it being upgraded to one of dishonesty, end quote. So this is not a case in which, for some tactical reason, SCAT deliberately kept hidden from EDNF man the possibility that a fraud claim might be brought against it. To the contrary, SCAT has been open with EDNF man about that fact. For those reasons, my lords, in our submission, the judge was right not to strike out the current claim, despite his finding that SCAT had breached the ALDI guidance. Or at the very least, that was not a perverse or plainly wrong decision. That is a decision that the judge was entitled to reach. Unless your lordships have any further questions for me on this aspect, those are my submissions.
I don't detect any. Thank you very much, Mr. Chris.
May I, before I sit down, my lord, may I just hand up a copy of the Indian judgment that my lord
please.
Popplewell was after? I don't propose to make any submissions about that, but if it is of assistance. Thank you, my lord.
So, Mr. Chapman, does that conclude your submissions?
It does, my lord. That concludes.
Thank you very much. Mr. Malik.
Well, Lord, if I can be brief, I'm obviously not going to repeat points already made, but just to pick up a few points. They may be regarded as rather random, but let me just go through them. Both sides have been asked about the extent to which issue estoppels can apply to issues of law. And my learned friend gave some materials on that today. There's one case that we would like to draw your attention to. It's a case called Watt and Assan. It's a House of Lords case in 2007. If I can hand that up now to your lordships.
Have your opponents seen this before?
It was emailed this morning.
Yes, I see.
And as I say, I can deal with it very briefly. It was, as the head note explains, there were two actions between a Labour Party member and the Labour Party. In fact, there may be a third one. The first alleged discrimination, the second alleged victimisation. And in the first case, it was determined that the Labour Party was a qualifying body for the purposes of the Race Relations Act. And the question was whether that was binding in relation to the second and third claims. And in paragraph 33, the principle is stated there that there was in fact an issue of estoppel, and your lordship can read that to yourselves. And the last sentence says the whole point of an issue of estoppel on a question of law is that the parties remain bound by an erroneous decision. I'm not sure where this goes, because the passage from Spencer Bauer, which was also referred to by my learned friends in the document that they handed up this morning, makes it quite clear that the determination will be found an issue of estoppel may be of law, fact, or mixed fact and law. And the proposition seems to be based on this Supreme Court of India case that there can be no issue of estoppel as to a pure question of law. This must be correct. But the reality is that in a case such as the present, there clearly, in our respectful submission, is an issue of estoppel for the reasons that I've given. Obviously, there's a mix of law and fact. This is not the kind of issue where perhaps the consideration example given by my Lord Justice Popplewell. Another might be where it's been held that a piece of legislation does not have retrospective effect. In my respectful submission, your lordships are not going to get assisted by reaching a decision as to what issues of law can be caught. There's obviously the Arnold case where that point, if my recollection is right, that point comes in. But that's all I wanted to say on that point. As to the authority that was cited this morning, the New Brunswick case, the only point I would make is that this decision was decided a long time before the Arnold and Nat West case. And in that case, and I'll give you, your lordships, the reference, it's page 216 at letter D, there is a discussion in that case as to whether default judgments are to be treated as special circumstances, disapplying an issue estoppel. But in my respectful submission, there's no principles that are established by the New Brunswick railway case, and therefore I don't propose to say anything more about that authority. I don't want to say anything more about the common issue as to how we formulated it in the light of the remarks by my Lord Justice Popplewell, but it is directed to applications conveying misinformation. It is not an identity case. There was no identity case for Mr. Justice Andrew Baker. That was made clear. Yes, he did treat that as an example of where the principles might not be applicable, but in our submission, the formulation of the common issue does not include identity cases. Now, the other point I wanted to make on issue estoppel is just to, there was a lot of emphasis on the phrase "as alleged," but if we could just, if I could just remind your lordships what Mr. Justice Andrew Baker said at paragraph 5. I did refer to it in my oral submission, but once again, it's at paragraph 5, is at J22, and your lordship will recall that passage where there's a reference to a submission generating a lot more heat. But as your lordship can see from the last sentence, in the event I have not found it necessary to resolve contentious matters of fact to reach a final decision concerning Dicey Rule 3. I'm not going to go through the authority, obviously, again, to remind your lordships as to what was the ratio in this case. But if I can just draw your attention to two passages by way of a reminder. The first is 107 at J50, where Mr. Justice Andrew Baker said the mechanism of alleged wrongdoing then may be the making of the WHT refund applications conveying misinformation, but the central interest of SCAT in bringing the claim of the right that in substance SCAT seeks to enforce are in point of form private law claims is SCAT's interest in right in collecting what was due by way of dividend tax for the tax years in question. Dicey Rule 3, a mandatory rule of English law, has the effect that there is no cause of action for a fraud on a foreign revenue, and I agree that the defendant's submission that at its highest SCAT's claims here are to be claims to have been a victim of the fraud. It cannot be sensibly say in relation to the claims pursued here that it was a victim of the fraud as might be committed against a private individual or corporate entity. And then at 112 across the page, the question of characterization as to how that is fundamental. And as I said, your lordship knows how I put the case, and I'm not going to repeat that. There was just one other point that I was going to cover, which I think comes out of a question that my Lord Justice Newey raised about whether the matter can be tested by asking whether the judgment would make sense without a particular determination, i.e. a private law claims for recovery of tax refund erroneously paid out are covered by the revenue. And the passage that I should draw the court's attention to is in the Authorities Bundle 3, tab 27 at 958, where there is a passage at the very bottom there at 958, paragraph 8.24 under the heading identifying the fundamental. And then there's a quote there from the Blair and Curran case. And then what is written then is this: the question is whether the determination was so fundamental that the decision cannot stand without it. Justice Dixon says that there is a further test, whether the determination is the immediate foundation of a decision and no more than part of the reasoning for the conclusion. So the question there as to whether the determination was so fundamental that the decision cannot stand without it. Now that, although the footnote doesn't make that clear, that proposition has been applied in other authorities. It was applied by the Court of Appeal in State of Norway's application number 2. And it's not, we haven't, just to give your lordship the references, 1991 AC 723.
Sorry, 1991 AC.
1990, volume 1, appeal cases at 723. But it's one of those cases where the Court of Appeal there, and it's Lord Justice May at 743, Lord Justice Balcombe at 752. It was applied by Lord Justice Moore-Bick in a case called P&O Ned Lloyd versus Arab Traders, 2007, One Weekly Law Reports 2288 at paragraph 23 to 24, and more recently by Mr. Justice Foxton in PG SA National Bank Trust versus Mintz, 2022, One Weekly Law Reports 3099 at paragraph 45. So that is a test that does have backing behind it. And we say that the characterization analysis conducted by Mr. Justice Andrew Baker, culminating in his conclusion that all private law actions reliant on these tax forms were subject to the revenue rule, is key to the decision. And if one were to remove all that language from the learned judge's judgment, there would effectively be nothing left. The judgment cannot stand without it. And that's why we say it's fundamental or essential step of the reasoning. Of course, there may be cases decided on one, more, or other grounds, in which case there may be arguments about what was the true ratio, but none of that arises in our case because there is a single line of logic running throughout the judgment. SCAT have been unable to point to an alternative narrow reading of Mr. Justice Andrew Baker's decision, and therefore we say that the only ratio is the broad proposition that private law claims to recover WHT refunds based on misinformation in tax vouchers are revenue rule claims. That's all I wanted to say on issue estoppel. As far as abuse is concerned, I've really got nothing further to say other than perhaps just to remind your lordship as to how we put this aspect of the case, which is essentially that if one looks at effectively the dates, and for that purpose, your lordships can turn please to C87, which is the core bundle, where we have this, we've read these passages so I can take it quite quickly, but we have Mr. Wade's report coming in the last week of January 2022. We have the passage that my Lord Justice Nugent just reminded us of at paragraph 90, which is to say that they could not plead fraud because SCAT still face a problem that unless and until the judgment of Mr. Justice Andrew Baker was reversed by the Court of Appeal, there could be no case against EDF MAT. And my friend, I think, has to say that that's wrong because he will be set. He says, well, no, that doesn't cover the fraud case. Because it's not issue estoppel. Now, we say obviously that that's wrong, but that illustrates, we submit, what is correct. In other words, that there was an estoppel that applied to the misinformation type claims. And then my Lord Justice New referred to paragraph 91, where we are recorded as saying we're correct to say that SCAT could have raised the existence, and your lordship stressed the could have, but in fact, if one turns down to paragraph 93, your lordship will see that what Mr. Justice Bright said about that particular period, he says this: however, whether or not SCAT had already made this decision, it could and should have done so. So that was at the time of the Court of Appeal. It says it must have anticipated the possibility that the appeal would succeed. It could and should have considered Mr. Wade's report in that light. And then, so then we get to the Court of Appeal. We then come to the CMC, where the judge is not told what the position is. It's just simply told it is not inconceivable that proceedings may be brought. That's paragraph 96. And then at paragraph 99, by the 6th of June, the claim is formulated in the terms of a letter of claim. And that's what, almost 2 years before the trial actually started. And that's really what our thrust of our case is in relation to the Aldi Stores point, is that here, against the background against a claim which had been brought, a lot of money and effort had gone into the case. We come out, they just say that they decided they're not going to pursue the revenue claim. So we come out, the expectation therefore that is the end of the matter. We're then brought in, but we're brought in late in circumstances where we face what I submit to be the deeply unsatisfactory position, where the court is faced with this prospect of a main action and a second action if my learned friend is not bound by the issue of estoppel, which we say relies on this case. And when one looks in terms of the interests that are being served here, I fully take the point about that it's not just a matter of private or interest, but the interest that we've got here is not being vexed twice. We've clearly been vexed twice, and that is, in my submission, harassment. And when one adds to that what's happened here in relation to this case that has been carefully managed over 4 years by a designated judge involving multiple parties, in my submission, it's so deeply unsatisfactory that we say, in those circumstances, the court, Mr. Justice Bright, should have said, no, it's game over. Those are my submissions.
Thank you very much. Mr. Chapman, you must have a right to reply on the new cases. I don't know whether you wish to exercise this, and I'm not encouraging you to.
No, I don't think I do need to say anything on those cases.
Thank you very much. But you will be staggered to know that we're not going to give judgment here and now. As you would expect, you will be supplied with the judgments in draft for you to correct our English and typing, but not to re-argue the case. We'd be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are any points on which you disagree, could you please have brief written submissions, and we would expect to settle the points in the order that we make. I ought to remind you of what you will already have well in mind, which is the importance that is attached to the embargo. You've helpfully supplied a list of people to whom the draft judgments should go. If you think of anybody else who should see a draft, then obviously you need to come back to us given the terms of the embargo. And that, I think, leaves it only to say thank you very much for very clear and, in the end, timely submissions from all four who have spoken, but also from everybody else involved. Thank you very much.
Thank you.